Development Act was passed by the Indian Parliament in April 2025. This legislation seeks to reform the Waqf Act 1995, addressing long-standing issues in the management of Waqf properties, religious and charitable endowment under Islamic law. The bill introduces sweeping changes to enhance transparency, accountability, and inclusivity while resolving disputes over Waqf lands. This article examines the changes from the previous law along with the pros and cons of the new amendments. Key changes in the Waqf Amendment Bill. Formation of Waqf. Old rule says that a Waqf could be formed by declaration, user, or endowment. New rule say New rule has removed Waqf by user. This means that properties can no longer be declared Waqf based solely on long-term religious use. Second point is only practicing Muslim for at least 5 years can dedicate property to Waqf. Third, women's inheritance rights must be settled before Waqf dedication. Second point is government land disputes. Old rules says there is no clear provision for government properties claimed as Waqf. New rule says government properties identified as Waqf will cease to be Waqf. Disputes will be resolved by collector level officer who submits a report to the state government. Third point is Waqf board composition. Old rule says all members had to be Muslims. New rule says two non-Muslim members included in central and state Waqf boards. Representation for Shia, Sunni, Bohra and Agha Khani communities wherever applicable. And third is at least two Muslim women must be member of the new Waqf board composition. Fourth point is Waqf tribunals and judicial oversight. Old rule says decisions by Waqf tribunals were final with no appeal in higher courts. Tribunals included a Muslim law expert. New rule says appeals allowed in high courts within 90 days. Muslim law expert removed, replaced with district court judge and a joint secretary level officer. Removal of section 40. Old rule says section 40 allow Waqf board to arbitrarily declare any property as Waqf. New rule says section 40 is abolished and preventing misuse of Waqf claims. Digital management and audits. New rule says centralized Waqf portal for property registration within 6 months. Mandatory audits for Waqf institutions earning over 1 lakh annually. Limitations Act 1963 now applies. Old rule says Waqf properties claims were exempted from time limits leading to prolonged litigations. New rule says that 12-year limitation period applies preventing indefinite dispute. Pros of Waqf Amendment Bill 2025. It is enhanced transparency through digital records and audits to reduce corruption and mismanagement. Second is inclusivity. Non-Muslim members in Waqf board promote secular governance. Third is women's right, ensures inheritance rights for Muslim women before Waqf declaration. Fourth is reduced litigation. Limitation Act prevents endless legal battles. Fifth is government land protection, prevents fraudulent Waqf claims on public properties. Cons of the Waqf Amendment Bill are infringement of religious autonomy. Critics argue non-Muslim inclusion interferes with Muslim self-governance. Risk to historical Waqf properties. Removal of Waqf by user may affect undocumented religious sites. Third is increased government control. More bureaucratic oversight may lead to delays and political interferences. And fourth point is potential for more disputes. Transferring dispute resolution to collectors instead of Waqf tribunals may create confusion. Conclusion, we can say that the Waqf Amendment Bill 2025 introduces significant reforms aimed at modernizing Waqf government governance, improving transparency, and protecting property rights, while it addresses long-standing issues like illegal encroachment and mismanagement. Concerns remains over religious autonomy, and government interventions. The success of this law will depend on its implementation and whether it balances community rights with administrative efficiencies.